9-0. Let that land for a second. Not 5-4, not 6-3, 9-0. Every single justice on the United States Supreme Court, including the 3 most reliably liberal justices on that bench, just agreed that major gun control laws across this country are unconstitutional. Sotomayor signed on, Elena Kagan signed on, Ketanji Brown Jackson signed on. When those 3 justices cannot find a legal leg to stand on to defend a law, that law wasn't just questionable, it was indefensible. And that is exactly what the Supreme Court just declared about some of the most aggressive gun restrictions in America. The Supreme Court just destroyed blue state gun laws. And most people watching this have no idea how deep that destruction goes or what it means for them starting right now. This isn't a talking point. This isn't spin. This is a constitutional ruling that rewrites the legal landscape of gun ownership in the United States, and the states that have spent decades building elaborate systems to delay, discourage, and effectively deny Second Amendment rights are now scrambling. Some are complying, some are stalling, and some are already engineering workarounds designed to look like compliance while preserving as much restriction as they can. You need to know all of it because the victory is real, but it is not automatic, and it will not protect itself. If you want to stay ahead of every development as states respond to this ruling, every legal challenge, every workaround attempt, every court fight that comes next, hit subscribe right now and turn on notifications. This story is moving fast, and the people who understand what's happening will be the ones who know how to protect what was just won. On April 24th, 2026, the Supreme Court handed down its decision in United States versus Henderson, a consolidated case that pulled together challenges to both federal and state gun regulations under the Second Amendment. And the court didn't just rule narrowly. It didn't split the difference or carve out exceptions for politically sensitive states. It came down hard, unanimously, and it drew a line in the constitutional sand that changes everything about how government can legally treat gun ownership in this country. The court established that strict scrutiny, the highest, most demanding standard of constitutional review that exists in American law, now applies to all Second Amendment restrictions. To understand why that matters, you need to understand what strict scrutiny actually means. In practice, it's the same legal standard applied to laws that restrict free speech. It's the standard applied to laws that burden religious liberty. Under strict scrutiny, the government doesn't get the benefit of the doubt. The government has to prove affirmatively, with evidence, that a restriction serves a compelling interest, that it's narrowly tailored to achieve that interest, and that it uses the least restrictive means available. That is an extraordinarily high bar. Most laws don't clear it, and the court just said that every gun law in America has to clear it or fall. Chief Justice Roberts, writing for a unanimous court, said something that should be read in every state house in America. He wrote that the Second Amendment codifies a pre-existing right, that government may not condition the exercise of that right on permission, approval, or delay beyond what is necessary to verify eligibility, and that the default position under the Constitution is liberty, not restriction, not delay, not bureaucratic approval. But liberty restrictions require the highest level of justification. That's not a conservative opinion. That's the unanimous opinion of the entire court. And then the court went further. It didn't just establish the standard and leave states to figure it out. It identified 5 specific categories of gun regulations that fail constitutional scrutiny, that are, as of this ruling, unenforceable nationwide. The first category is permit-to-purchase systems, laws that require you to obtain government approval before you're even allowed to buy a firearm. Illinois had it, Massachusetts had it, Connecticut, Maryland, New Jersey, Hawaii, Rhode Island, all had it. The court held these are prior restraints on constitutional rights. The same legal concept that makes government pre-approval of newspaper articles unconstitutional. You cannot require a citizen to get government permission before exercising a fundamental right. It's that simple, and the court said so unanimously. The second category is extended waiting periods, mandatory delays that go beyond the time actually needed to complete a background check. California had a 10-day wait. Florida had 3 days, Rhode Island had 7. The court's position is clear. Background checks are legitimate. Once that check is complete, forcing someone to wait days or weeks to take possession of property they have a constitutional right to own is to Unconstitutional. The third category is mandatory training requirements as a prerequisite for owning or carrying a firearm. States cannot require you to complete a government-approved training course before exercising Second Amendment rights. Training can be offered, it can be encouraged, it can be funded and promoted, but it cannot be mandated as a gate that stands between a citizen and their constitutional right. The fourth category is good cause and proper purpose requirements. The old may issue standard that lets states demand you prove a special reason why you need to carry a firearm. California, Hawaii, Maryland, and a handful of counties in other states still use this. No longer the right to carry is a right itself. You don't have to justify exercising a constitutional right to a government official. The fifth category is discretionary approval systems. Any system where an official has subjective authority to deny a permit based on vague standards like suitability or character. All permits, the court said, must be shall issue, based only on objective, verifiable criteria. You meet the criteria, you get the permit. An official's personal judgment about whether you seem like the right kind of person has no place in constitutional law. Here is where this ruling stops being abstract and starts being something that changes real lives in real places. Not every state feels this equally. The states that spent the last several decades building the most elaborate systems of restriction are the ones that just had the most knocked down. And the scale of what some of these states are losing is genuinely staggering. California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Illinois, Connecticut, Delaware, and Rhode Island are the states most affected, losing 10 or more significant restrictions as a result of this ruling. These are the states that had permit to purchase systems, long waiting periods, training mandates, may issue carry standards, and discretionary denial authority. All of it now unconstitutional, all of it at once. Think about what that means for someone who lives in California. The 10-day waiting period is gone, reduced to however long the background check actually takes, which in most cases is 1 to 2 hours. The firearm safety certificate that California required before purchasing any firearm is now voluntary, not mandatory. The counties that operated as may issue jurisdictions, routinely denying carry permits to ordinary citizens who couldn't demonstrate a specific threat to their safety, must now issue permits to anyone who meets objective criteria. That is a fundamental restructuring of how California treats gun ownership. And it happened overnight. In Illinois, the FOID card, the firearm owner's identification card, that residents were required to obtain before they could even legally possess a firearm in their own home, is struck down. The 72-hour waiting period is gone. In New York, the Concealed Carry Improvement Act's training requirements, the ones enacted as a direct response to the Bruen decision, are void. In New Jersey, the permit to purchase system is invalidated. These are not minor tweaks. These are structural collapses of regulatory frameworks that took decades to build and were treated by their supporters as settled, permanent features of those states' legal landscapes. The moderately affected states, Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, Florida, lose 3 to 5 restrictions, waiting periods, certain training requirements, local discretionary systems, real changes, but not the complete overhaul that the most restrictive states are facing. And then there are the 25 constitutional carry states and the shall issue states that already operated with minimal restrictions: Texas, Florida, Georgia, Arizona, Tennessee. And for them, this ruling is largely a confirmation of what they were already doing. They're compliant by default because they never built the systems. The court just struck down. What this map tells you is important. For years, gun control advocates argued that restrictive states were simply exercising legitimate regulatory authority within constitutional limits. What this unanimous ruling says is that those states weren't operating near the edge of constitutional permission. They were operating well outside it. Every one of those restrictions had been defended in court, often successfully at the district and circuit level. And yet, when the case arrived at the Supreme Court, not a single justice, not even the 3 most committed to upholding gun regulations, could find a constitutional defense for them. Let's talk about what this actually means for a person, not for lawyers, not for legislators, but for someone who owns a gun or wants to own one and has been navigating the maze of restrictions in a state like California, Illinois, or New Jersey, because the practical changes are immediate and significant, and most gun owners don't yet fully understand the scope of what just changed for them. If you live in a state that had a permit to purchase requirement, Illinois, Massachusetts, Connecticut, Maryland, New Jersey, Hawaii, Rhode Island, you can now walk into a gun store, submit to a background check, and if you pass, walk out with a firearm. The same process that already applied to purchasing a rifle in those states now applies to purchasing a handgun. No permit card, no prior government approval, no waiting for bureaucratic processing of an application that might take weeks or months. You have the right. You meet the eligibility criteria. You exercise the right. If you live in a state with extended waiting periods, those waiting periods are now reduced to the actual time needed to complete your background check. In most cases, that's hours, not days. California's 10-day wait, which gun owners had to endure even for their second or third purchase, is gone. Florida's 3-day wait, which applied even when the background check came back immediately, is gone. Rhode Island's 7-day wait gone. You pass the check, you take your firearm home. If you've been living in a former May-issue jurisdiction and wanted a carry permit but knew you'd be denied because you couldn't prove you faced specific personal threats, that system is over. The right to carry is presumed. You apply, you pass the background check, you meet the objective criteria, and the state must issue your permit. Period. No justification required beyond your eligibility. If you've been hesitating to purchase a firearm because of mandatory training requirements, because you couldn't afford the course, couldn't take the time off work, or simply resented being required to complete government-prescribed instruction before exercising a constitutional right, those requirements are unenforceable. Training is recommended. Many people would benefit from it, but it is no longer a gate you must pass through before the government will allow you to own a gun. And if you've been denied a permit in the past by an official exercising discretionary authority, deciding you weren't the right kind of person, that you didn't seem sufficiently responsible, that your suitability didn't meet some undefined standard minus that kind of subjective denial is now unconstitutional, officials must apply objective criteria. If you meet them, you get your permit. Their personal judgment about you is irrelevant. This is a real, immediate expansion of rights for millions of Americans who have been living under restrictions that the highest court in the land just unanimously declared unconstitutional. That matters, but it doesn't mean the path forward is frictionless, because some states are not going to accept this quietly. You're in the middle of something that's going to keep developing for months. Every week, there will be new legal challenges, new workaround attempts, new court fights. If you want to stay ahead of all of it, subscribe right now. Drop a comment below telling me which state you're in and what restriction you're most relieved to see gone. Let's talk about it. The conversation happening in the comments on these videos is some of the most informed discussion happening anywhere on this topic, and I want you in it. Not every state is going to roll over and implement this ruling cleanly. Some will, most won't, at least not without a fight, not without attempting to replace what was struck down with something new that accomplishes the same goal through different means. Understanding how states are responding is critical, because the legal victory won at the Supreme Court has to be defended on the ground in every state that decides to test the limits of the ruling. The states already in compliance are easy to identify. They're the constitutional carry states and the shall issue states that never built the systems, now declared unconstitutional. Texas, Georgia, Arizona, Tennessee, they don't need to change anything. They were already operating within the constitutional framework the court just defined. For gun owners in those states, the ruling is largely an affirmation and a protection against future overreach. The states in the middle, California, Washington, Oregon, Colorado, are in what might be called a delayed compliance posture. They've acknowledged the ruling, and they've indicated they need 30 to 90 days to update their systems, retrain staff, revise forms, and adjust procedures. That's technically understandable for states with large, complex administrative systems, but watch closely during those 90 days, because the administrative process of updating systems is also the opportunity to quietly install new barriers before anyone is paying attention. And when California says it needs 60 days to revise its background check process, the question you should be asking is, what exactly are they revising, and what new requirements are being written into those revised procedures? And then there are the resistant states: New York, New Jersey, Illinois, Maryland, Massachusetts, Hawaii. These states are not interested in accepting this ruling as the end of the debate. They are actively exploring what legal theorists sometimes call constitutional workarounds, new regulatory schemes designed to technically comply with the letter of the ruling while preserving as much practical restriction as possible. The playbook is already visible. Permit to purchase is gone, so replace it with mandatory free training that happens to have a 6-week waiting list and requires government scheduling. Extended waiting periods are gone, so substitute cooling off justifications framed as safety measures rather than delays. May issue is dead, so shift to shall issue with objective requirements that are written to be difficult for most people to meet. Every one of these workarounds will be challenged in court. Gun rights organizations are not waiting for states to finish writing the new rules. They are watching the drafting process and preparing litigation before the ink is dry. The legal standard the court established, strict scrutiny, is what makes those workarounds so difficult to sustain. Under strict scrutiny, the state doesn't get to say, we believe this restriction makes people safer, and have a court defer. To that judgment, the state has to prove it with evidence, and it has to show that the restriction is the least burdensome way to achieve that goal. A mandatory training program with a 6-week government scheduling backlog is not narrowly tailored. A cooling off period of 7 days when background checks take 2 hours is not the least restrictive means available. These arguments will be made in federal courts across the country and under strict scrutiny. States are going to lose most of them. The ruling itself matters enormously, but the vote is what changes the trajectory of this issue for a generation. Unanimous Supreme Court decisions in major constitutional cases are extraordinarily rare. Brown versus Board of Education was unanimous. Miranda versus Arizona was not. It was 5-4. Roe versus Wade was 7-2. The landmark Heller decision that first established an individual right to keep and bear arms was 5-4. McDonald, which applied that right to the states, was 5-4. Bruen, which struck down New York's May issue system in 2022, was 6-3. This ruling, a ruling that goes further than any of its predecessors, that applies the highest standard of constitutional review, that strikes down 5 categories of restriction simultaneously, went 9-0. That unanimity sends a message that no politician, no state attorney general, no gun control advocacy group can easily spin when the 3 most reliably liberal justices on the Supreme Court cannot construct a constitutional defense for permit to purchase requirements and extended waiting periods. Those requirements were not operating in a constitutionally gray area. They were unconstitutional, full stop. And the legal and political cost of continuing to defend them became too high, even for justices who have spent their careers on the bench supporting gun regulation. Roberts' majority opinion, joined by all 8 other justices, also explicitly rejected what's called interest balancing, a legal approach that had allowed lower courts to essentially weigh the policy benefits of gun restrictions against the constitutional burden they imposed. Courts had used interest balancing to uphold all sorts of restrictions by simply deciding that the public safety benefits outweighed the rights infringement. The Supreme Court shut that door. Rights, Roberts wrote, do not depend on judges' policy preferences. The Second Amendment means what it meant at ratification, and courts don't get to override it by deciding that a different policy would produce better outcomes. That rejection of interest balancing, combined with the establishment of strict scrutiny, creates a framework that is extraordinarily difficult for gun control legislation to survive. Assault weapon bans will face strict scrutiny challenges they cannot easily survive. Magazine capacity limits will face the same. Red flag laws without robust due process protections, laws that allow guns to be seized before any hearing, any adjudication, any real opportunity to contest the seizure, are now deeply vulnerable, and age restrictions beyond 18, which several states had pushed to 21 for certain purchases, will be litigated under this new standard. And the landscape of what government can legally do to restrict firearms just shrank dramatically, and it shrank unanimously. Congress is effectively frozen when it comes to new gun control under this framework. Universal background checks might survive strict scrutiny if written narrowly enough. Background checks are a legitimate means of verifying eligibility, and the court specifically said states can require them, but assault weapon bans won't survive, magazine limits won't survive. Any restriction that isn't narrowly tailored to eligibility verification and historically grounded in founding era practice is going to face an extraordinarily hostile legal environment. For state legislators, the era of experimental gun control, passing restrictions that seem politically popular and defending them in court while they remained in effect for years or decades, is over. The rules have changed. Every new law must be historically grounded, narrowly tailored, and the least restrictive means available from the moment it's drafted, because it will be challenged immediately and the state will have to defend it under strict scrutiny from day one. That changes the incentive structure for legislators who have used gun control legislation as political currency, regardless of its constitutional durability. For gun rights litigators, this ruling is a foundation they've been trying to build for decades. Every entrenched restriction that survived previous legal challenges under more permissive standards is now vulnerable to a new challenge under strict scrutiny. Laws that survived 5-4 decisions in circuit courts, that were upheld under interest balancing analysis, that were allowed to remain in effect because courts gave deference to legislative judgment. All of them are now candidates for renewed litigation. The queue of potential cases is long, and the legal environment for winning them just improved dramatically. For ordinary gun owners, particularly those in the most restrictive states, this is the most significant practical expansion of Second Amendment rights since Heller. Not because of what the court said in the abstract, but because of what people can actually do. Walk into a store, pass a background check, and exercise a constitutional right without asking anyone's permission first. This victory is real, but victories that aren't defended, understood, and actively exercised have a way of eroding. Here is what you need to do, not what you might consider doing, not what would be a good idea someday. What you need to do right now: first, know specifically what changed in your state. If you live in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions just became unenforceable. But the details matter: which specific regulations in your state are now void, which remain valid, and what the transition looks like. The NRA, the Second Amendment Foundation, and the Firearms Policy Coalition all have state-specific guides being updated in real time. Read them. Know your rights specifically, not generally. Second, if you've been waiting to purchase a firearm because of permit requirements or waiting periods, stop waiting. The court just removed those barriers. States may attempt to reinstall them through new legislation. And while those new laws will likely be struck down, they could create confusion and delay in the interim. Exercise your rights now under the ruling as it stands today. Third, if you're in a former May-issue jurisdiction and want a carry permit, apply immediately, before states have time to write new objective requirements designed to be difficult to meet. Apply under the current shall issue standard the court just mandated. Document your application, document the timeline, and if you're denied or delayed unreasonably, contact a gun rights organization immediately. Fourth, document any attempt by state officials to enforce invalidated laws. If you go to purchase a firearm and an official tries to impose a permit requirement that no longer exists, document everything: names, dates, what was said, what was demanded. State violations of Supreme Court rulings are grounds for federal civil rights lawsuits under Section 1983, and gun rights organizations are actively looking for clean cases to litigate. Fifth, support the organizations doing the legal work: the Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America. These are the groups that will be in court challenging every state workaround for the next several years. That work costs money and requires members. The court won this round. Keeping it will require sustained litigation. Six, stay engaged with what your state legislature does next. The most restrictive states are going to pass new legislation. Some of it will be genuine compliance. Some of it will be carefully engineered restriction, wearing the clothes of compliance. Pay attention, read what's actually being proposed, and oppose what crosses the line. Your legislators need to hear from you before they vote, not after. Seventh, and this is the one that matters most in the long run: vote like this ruling depends on it, because the next one does. This ruling happened because the court has the composition. It has future rulings, future confirmations, future appointments, all depend on elections. And the people who want to rebuild what was just struck down are not going to stop wanting it. They're going to work through elections, through appointments, through every available mechanism. So must you. The Supreme Court just issued the most significant gun rights ruling in American history. More significant than Heller, more significant than McDonald, more significant than Bruen, unanimous, broad, structurally transformative. The 5 categories of restriction struck down: permit to purchase, extended waiting periods, training mandates, good cause requirements, discretionary approval were the scaffolding on which the most restrictive gun control regimes in this country were built. That scaffolding is gone. What gets built in its place, whether it respects what the court just said or tries to route around it, depends entirely on how informed and engaged gun owners are in the months ahead. Stay sharp, stay informed, stay engaged, because this fight didn't end on April 24, 2026. It just entered its next phase. If this breakdown gave you something real, actual understanding of what this ruling means and what comes next, share it with every gun owner you know, because most of them have no idea the legal ground just shifted under their feet. Subscribe if you haven't already, and drop a comment telling me what state you're in and what question you still have about how this ruling affects you. I read every comment, and your questions shape what I cover next. The people who know what's actually happening are the ones who can actually protect it. Be one of them.